There is not a right to counsel in civil cases. And so the court is not going to wait around for a defendant to hire an attorney or a responding party, an interested party, to hire an attorney or appoint an attorney to help someone in a civil forfeiture case. Hello again, it's Lana Manitta with Rossen Law Firm. I'm here to talk to you today about criminal forfeiture versus civil forfeiture arising in the context of federal criminal cases. Before we get started, remember to like and comment on this video and subscribe to our channel, where we provide a variety of educational videos on criminal defense topics. So forfeiture law is very complicated, and it often takes federal defendants and even federal criminal defense attorneys by surprise exactly how broad the government's power is to get at a defendant's property. It's often misunderstood because it seems, frankly, unfair to a degree that really doesn't make sense a lot of the time, but it's all true. So I'm really only going to be scratching the surface with respect to forfeiture and explaining the very basic difference between civil and criminal forfeiture. But if this is a topic that interests you, comment on this video and let us know, and we can try to break it down into sort of bite-sized chunks in future videos, because it's definitely a bear of a topic. So criminal forfeiture comes, as you might expect, as a consequence of a criminal conduct or a criminal conviction. Often, the forfeiture is a count within the indictment or the information against the person. The charging document actually includes a forfeiture count. And in that forfeiture count, it basically says, there is property that was either the proceeds of this offense or used in the commission of this offense, to wit, $50,000 cash, or a firearm with serial number XYZ, or real property with an address, or a vehicle with a VIN number. It can be anything. And the federal government has in personam jurisdiction over this. It's an in personam matter because it's within the case against the person, against the defendant, okay? The case is against the person who is alleged to own the property, to have used the property, or gained the property through this criminal behavior that is charged in this document. And again, it means that the government has identified and alleged that this piece of property is proceeds or instrumentality of the charged offense and is seeking forfeiture on those grounds. It's not a foregone conclusion that they are correct. So defenses to this claim can be raised, that the assets have no connection to the criminal activity, or a third party might come in and make a claim that the property belongs to them and they had no part in the criminal conduct. And so these are defenses that can be raised, and there are a host of other defenses, including defenses to the underlying offenses, but we won't get into that here. Now, civil forfeiture is an action. It's a civil action, not a criminal action, and it's filed against the property itself. It's called an in rem action because it's against the piece of property, and it'll be, in re 555 Maple Avenue, or in re, Isuzu Trooper VIN number XYZ. I don't think anybody has an Isuzu Trooper anymore. I don't know why that vehicle popped into my head, but in any event, it's a suit against the property itself for the forfeiture and the seizure, forfeiture, and ultimately the sale of that property. But it can still be used to seize property that the government says is connected to criminal activity. That's why I'm talking about it today in the context of criminal defense. Now, you might have guessed that because it's not in an indictment and it is a civil case, the allegations don't have to be proved beyond a reasonable doubt. It's it's a preponderance of the evidence standard in civil cases. So the government in civil forfeiture only has to prove the connection between the property and the criminal activity by a preponderance of the evidence. And a burden is really placed on the defendant to offer proof that it is not connected to criminal activity. Whereas in a criminal proceeding, the defendant really doesn't bear a burden of production or persuasion unless it's an affirmative defense. And there is a beyond a reasonable doubt standard of proof brought to bear on the government. There is also a right to counsel in criminal cases. There is not a right to counsel in civil cases. And so the court is not going to wait around for a defendant to hire an attorney or a responding party, an interested party, to hire an attorney or appoint an attorney to help someone in a civil forfeiture case. It is important that when you are facing forfeiture, as part of a criminal case, either through an indictment, an information, or a civil forfeiture proceeding that's alleging connection to the criminal conduct, or if you're charged with a federal offense and you have assets that you think the government might try to take through the civil forfeiture process, or they might file a superseding indictment that has a criminal forfeiture count in it. If you're concerned about your property and are facing criminal prosecution, it's very, very important that you hire counsel who understands the different types of forfeiture and knows how to negotiate or challenge the government when they make efforts to take property. If you have a matter involving federal forfeiture, contact Rossen Law Firm today. Schedule a strategy session and see what can be done to try and safeguard that property. Remember to like and comment on this video, subscribe to our channel, and as always, thank you for watching.